Welcome back to day 2 of our second annual UK Competition Litigation Conference. And thank you for joining us for the panel discussion on lessons learned in strategic case management.
Hi, good afternoon, everyone. Thanks for joining us. I'm joined today by 3 members on our panel. Leslie Hanno is a partner at Hausfeld. She's currently working a lot of the dominance matters against Google, most notably for Foundum, and also expanded into the data breach sector in a representative action against YouTube. Ewan Burrows is also on the panel today. He's a partner at Ashurst and is the head of the competition team there. He's currently working on the trucks matter on the claimant side, amongst other things. And finally, last but not least, Cassie Smith QC, who frankly has worked on pretty much every competition case out there. So she's got great experience on both the claimant and defence side, and I'm very much looking forward to having a lively discussion with all of you in respect of today's session on strategic considerations in case management. The main topics today are going to be disclosure, funding, settlement, and expert evidence, and we'll run through things in that order. So very much invite anyone in the audience to be sending your questions in as we go through, and we can pick them up as we go. So to kick off with disclosure, I thought I'd hand over to Cassie to comment a little bit on the standards of burden for proof, most notably coming out of the interchange judgment recently.
Thanks, Simon. I'm going to just make some comments by way of opening on, as Simon said, the recent Supreme Court judgment that was handed down in June of this year in Sainsbury's and MasterCard. And one of the issues considered by the court was the question of burden of proof as regards what it called mitigation of loss, what most of us have always thought of as questions of pass on. And what has been causing particularly claimants a great deal of interest, possible headaches arising from that judgment is what the Supreme Court said in paragraph 216 of its judgment. It said, perhaps unsurprisingly, that the legal burden was on Visa and MasterCard as operators of the scheme that merchants have mitigated their loss or passed on their loss, of whether it could be proved that merchants had reduced their loss, mitigated their loss by way of reducing their other costs, as well as passing on the MIFs, the unlawful MIFs, to their customers in the prices that they charge to those customers. So the Supreme Court said, as I've said, that the legal burden is on Visa and MasterCard to establish mitigation. But the Supreme Court then went on to say that once Visa and MasterCard have raised that issue of mitigation in the form of pass on, there's then what was described as a heavy evidential burden on the merchants to provide evidence as to how they deal with the recovery of costs in their business. And the Supreme Court said this is because it's the merchants who have that material, who have the documents, who have the evidence as to what they do, how they price, how they deal with cost, how they have dealt with the charging of MIFs or the increasing of MIFs. And the Supreme Court said then explicitly that the merchant must produce that evidence in order to forestall adverse inferences being taken against it by the court, which seeks to apply the compensatory principle. So although the legal burden is on the merchants, it really does appear that the heavy evidential burden is on the merchants bringing the claim. And what does that mean? And what impact will that have on questions of disclosure? Well, it seems pretty clear that there will be a disclosure burden on the claimants. You can't just sit back on claimants. You can't just sit back and let Visa and MasterCard do the running on pass on as you might have hoped in the past. So what should claimants think about in these types of cases? Because of course, pass on is going to be a very fact-specific, case-specific issue, which will turn very much on the nature of the claimant's business and how they deal with issues of cost and pricing. So it seems to me that there are 2 things that claimants need to think about in particular. First of all, the impact on pleading your case. In the past, you may, as a claimant, have thought, well, the issue of pass on is something that it's up to the defendants to bring up in the defence, and that's the end of the matter pretty much. Then I deny it in my reply, and that's the end of the matter. It seems to me that it might now be sensible for claimants to think about pleading at a relatively high level, or at whatever level is possible, some material, some detail on how they go about setting their prices, how they deal with the costs of MIFs, if MIFs feature at all in the question of how they set their prices, and how they negotiate whether MIFs have any impact on the other costs that they incur, and how they might mitigate the loss arising from the charging of MIFs. That's the first issue, because it's the pleadings, in my experience, which then form the focus of the subsequent second issue, which is the question of disclosure. Because I think there will be, in light of the Supreme Court's judgment, an expectation on the courts that this will be a pretty heavy disclosure burden, or there will be a pretty heavy disclosure burden on the claimants to show how, or to reject the question of pass on. And also, I think it's very interesting then to think about how you manage disclosure, because as a claimant, the issue of how do you set your prices, how do you deal with the cost of MIFs, could give rise to a huge and very vague and very onerous disclosure request or disclosure burden. So I think it's important, first of all, as I said, to try and set the scene for disclosure in your pleading, and then think about how best to manage disclosure. A lot of these MIFs cases, if not all of them, are being transferred to the Competition Appeal Tribunal. So in the case of MIFs, where this will probably come up in the very near future, but I don't think the Supreme Court judgment is limited, of course, to MIFs claims. I think it has an impact on all types of damages claims. But there are some very interesting issues that have arisen recently as a result of the tribunal's approach to disclosure. And one opportunity, one possibility that claimants might think about, or all parties might think about, is using an approach that I understand has been taken by the tribunal in the trucks litigation, in a slightly different context, about establishing the prices for the trucks that were sold. And in that context, I think, and it may be that others can give a bit more detail or colour on this issue, but as I understand it, in that case, the tribunal suggested that before engaging in the disclosure exercise, it might be a useful exercise for the, I think it may have been in that case the defendants, but in this case we're talking about a pass on, for the claimants to produce witness evidence, produce statements addressing the question of how they set their prices, how they deal with the costs of MIFs. And that would form the basis then for a targeted application for specific disclosure. So that might be a way of dealing with the potentially huge burden of a very vague disclosure exercise of produce every document that your company has produced for the last 10 years on questions of pricing, which is not going to be very useful to anyone. So that's just some thoughts about recent developments in the burden of proof and how that affects disclosure. But I'd be interested to hear what others have heard or have experienced in their cases and their litigation.
Yeah, thanks, Cassie. It's probably a suitable juncture to open it to you, and perhaps to comment, since you mentioned trucks, and to the extent you're able to elaborate on that.
Certainly, Simon. So there is a theory that presently disclosure is almost quasi unnecessary in some competition cases, and certainly a novel approach is being followed in trucks, whereas Cassie mentioned we have these so-called pricing statements that are produced, which are almost akin to a witness statement. And then any necessary disclosure following that is to be progressed by way of Redfern schedule, which obviously has the a laudable intention of minimizing disclosure, but has, to a degree, I think, elongated the process as a whole. Because plainly these individual categories are then subject to extensive correspondence between solicitors. So I think that would be kind of like the initial observation I would make in respect of certainly what's happening in trucks. I don't know, Leslie, whether you've got any thoughts as well in terms of what you're seeing.
Well, we adopted a rather different approach when we were litigating the air cargo case, where we produced preliminary expert reports specifically focused on the issue of pass on for each of the client groups. And that was, as I'm sure you'll understand, was quite an undertaking where you're involved in group litigation. So there were over 500 claimant entities in that litigation, from around 100 claimant entities. And that made the process of producing pass-on reports for each of the companies within a particular corporate group very complex, and I think was potentially quite an expensive and time-consuming approach to adopt. So I will be very interested to see how the courts approach this issue, I think, as we see increasingly large group claims, because tackling the issue of pass-on and perhaps witness evidence where you have one claimant is a rather different exercise to where you have 100 different claimants and are therefore producing 100 different reports for each of those claimants.
Yeah, thanks, Leslie. Of course, yeah, most of the disclosure we've been talking about here is very much centered around the quantum side of things, because so many of these cases are follow-on cases. But I think increasingly we're seeing standalone aspects to claims or standalone claims outright. And in that context, you may well be narrowing disclosure in respect of quantum, but you've also got the liability and causation side of things to deal with in those standalone claims. So I thought I'd open it up to the floor. Any comments on that?
Yeah, so a few thoughts on that, because again, in terms of the liability head, you have particularly in a follow-on claim, you have the decision. It might be a skinny settlement decision, but the question is legitimately asked: how much more disclosure do you need? Should you not really be focusing upon causation and quantum? Well, of course, as we all know, many of the features of a cartel and how it operated will bear directly or indirectly upon the damages claim itself. You'll have questions such as the scope of the cartel, the products affected, the duration. There may be interesting questions about the level of the supply chain or indeed aspects of pricing policy that were affected. So all of these issues do become very relevant, and there has been some really quite important jurisprudential developments in this area, some of which I think were mentioned yesterday. So in particular, there's been some clarification about the, if I can call it, the bindingness, if indeed that is a word. It's certainly a word that's been used a lot, of commission decisions. I mean, it's a relatively well-established principle that the operative part will be binding together with those aspects that form the essential basis for it. But again, as was discussed yesterday, the issue of whether it becomes an abusive process as a matter of English law to look to contest, if you like, to bring those points back into issue has now been decided by the Court of Appeal, and indeed, providing that stands, it will be. But I think maybe just a couple more quick points on if you like, the kind of liability issue. The primary source of disclosure in that context is usually the commission file. Back in 2018, we again had quite an important judgment in Trucks about access to the commission file. And in particular, that was the first access that was determined pursuant to the application of the Damages Directive in the UK, which had an interesting effect actually in the English process of in some ways actually narrowing the scope of disclosure that can be obtained from the commission file, in the sense that the need to identify individual categories when seeking access to the commission file was upheld, whereas previously a slightly wider approach had been permitted. So I think possibly I can hand over there. There are some interesting other points to make around causation if we have time, but let me stop there.
No, that's helpful. I mean, I think conscious of time to make sure we cover everything today, and I think given that you've mentioned the commission file, it's probably a suitable point to ask Leslie to elaborate on some of the other aspects of disclosure, potentially third party, to the extent it's needed to gain access to that.
Thanks, Simon. Yeah, I was just going to pick up on Ewan's point about applications for access to the Commission's file, which are made under the Damages Directive, because I thought it would be interesting to contrast approach taken in other jurisdictions. So I spoke to both my German and my Dutch colleagues to find out how whether there are active applications in Germany and the Netherlands, whether this is a process that is being commonly used in other jurisdictions. I was very interested to find out that although our courts have ordered such disclosure, that in fact in Germany they are not aware of any application having been granted by the German court. And I know from having talked to a law firm in the Czech Republic that that is something they are very interested to explore in the Czech Republic. But it is something they approach with a degree of apprehension because their courts are not as familiar with the concepts around disclosure and are perhaps more reticent to order disclosure from the Commission's file, notwithstanding the clear basis for that in the Damages Directive. I was also interested, actually recently chatting to my colleagues who are working on the Evans FX claim, and they had used Regulation 1049 of 2001 to make an application for disclosure of the Commission's decision before the non-confidential public version was made available. And I thought that was quite an interesting approach to getting hold of information at an earlier stage in the proceedings. I had a couple of attempts at getting hold of Commission decisions before the public version is made available, simply through disclosure orders from the English court. And that has, I think, resulted in quite lengthy processes with the various defendants making their redactions to those decisions before we were able to get hold of a copy. And it strikes me that perhaps the direct route to the European Commission to make that application directly is perhaps a faster approach. I note that under that regulation, the Commission has to deal with such applications promptly. And I think the turnaround time is supposed to be in the region of 15 working days, which I can say is certainly a lot faster than I have received copies of the Commission's decision when we have gone through the English court process to get hold of them. So I thought that was an interesting development flag in the FX litigation.
Yeah, absolutely. And, potentially, post-Brexit, very interesting twist on that. Presumably, much of this is very confidential material. You mentioned, before the release of a non-confidential version of a decision. So presumably there are mechanisms there, confidentiality rings, etc., which need to be used, and that's typically a key feature of these types of cases. And for the benefit of the members of the audience who are not English lawyers, perhaps a little bit of a background on that before you dive into how that's played out and how you use the confidentiality rings.
Thanks, Simon. Yes, I think there are certainly a few cases, sorry, Cassie, a few cases where there are multiple levels of confidentiality rings. I know you and I think you have an inner ring, an outer ring on trucks. I know that we have on Findham, we have an LEO ring, so legalize only, restricted legalize only ring to which only a very limited number of individuals are admitted. There are also a general confidentiality ring, separate confidentiality rings for information that's come from third parties. So I think it's increasingly commonplace to be navigating that. I don't know, Kathy, if you will also undoubtedly have come across a number of sets of rings on some of your cases.
Yes, I mean, they originally, I think they came about being used by the tribunal specifically in regulatory appeals, where often there was an appeal by one of the parties being, for example, in a market investigation, one party was appealing what was then the OFT's decision, and that decision had been based on an investigation carried out by the OFT, and obviously the OFT, for example, had got hold of a huge amount of information from the market generally, and so from lots of competitors. And in that situation where competitors were potentially seeing each other's confidential pricing information, what have you, confidentiality rings are extremely important. However, my experience of operating confidentiality rings, particularly when you get to trial, is from the counsel point of view, they're extremely burdensome, extremely clunky. There's a danger of having to go in and out of private hearings if you're trying to refer to confidential information in submissions. There's a danger that people refer to confidential information by mistake. They can be incredibly clunky and incredibly burdensome, and that's without even thinking about all the work that had to be done behind the scenes before we even got to a hearing, of ensuring that all the material was properly marked up for confidentiality in about 6 different colours to make sure that the different levels of the confidentiality ring, certain information could be shown to some people but not others, and so you had to make sure that it was all worked up. I do think that the operation of confidentiality rings obviously has become more and more common, but you need to keep in mind that they are very costly and very burdensome for parties to operate. And you do need to think, are they really necessary? I mean, the pricing information, yes, pricing information that is recent, obviously may need to be protected. But when we're talking in a cartel case, pricing information from 15, 20 years ago, really, I think, people have to be a bit sensible about these things and think, is this really confidential information that needs to be protected? Because once you start down that, they can become, I think, extremely, extremely burdensome, extremely difficult to operate, and let alone costly to operate.
It's an interesting point you made, Cassie, about the burdensome nature of confidentiality rings. That was something we came across recently in the Foundum litigation, where, as I mentioned earlier, we have a number of sets of rings, including a legalise only ring to which only the client's legal advisors are admitted. And then further, there is a restricted legalise only ring to which there are only a very small handful of the client's legal advisors admitted. And as you say, when you're in the context of a hearing and your client has to leave the courtroom, I think that does pose real difficulties, not least in terms of taking instructions, but also in terms of being able to explain to the client what's happening, what are the decisions being made by the court in reliance on that information. And there was an interesting judgment in the Foundum litigation earlier this year on issues around confidentiality rings. So that was March 2020, where there was a hearing, so following a strikeout application by Google in respect of certain standalone elements of Foundum's claim. Google filed evidence that was within the LEO and the RLEO rings in that case. And we requested permission to have our technical expert admitted to those rings in order that he could advise us. And I think in some instances, of course, there's just pricing information in those rings, but in this particular instance, there was technical information that, as lawyers, we're not qualified to understand it in the slightest. And so our client sought the admission of her expert into the ring, which was refused by Google. So we had a hearing, the outcome of which was the court said Google had a choice to make. It could either admit our technical expert into the ring so that he could advise us in relation to that confidential information, or Google had to cease relying on that information in its strikeout application. And it was really interesting, Roth's judgment in that he was, I think, fairly scathing about what he deemed to be the sort of the overuse of confidentiality rings in competition damages proceedings. But also he reiterated the fundamental principle that comes out of Supreme Court's ruling in Al-Rawi, which was that essentially a party has the right to know the case against them, and there really have to be exceptional circumstances where information that is central to a case is withheld from a party. And in those instances where there are those truly exceptional circumstances, then any information that is withheld should be limited to the narrowest extent possible. And I thought that was quite a pragmatic way of approaching what was obviously a hotly contested issue by a tech company who, rightly is concerned about the wider dissemination of its highly confidential algorithmic information. So that was quite an interesting decision.
Thanks, Leslie. I mean, you've got a comment there, please.
I was just going to offer a final observation on disclosure, if it takes us away from the topic of confidentiality rings, if that's permissible. It's often a relief. But the tribunal did issue quite an important ruling, which has a neutral citation of 2020 Cat 3 on disclosure, and it's titled Ruling Disclosure, and that I think contains some quite interesting pointers in certainly in follow-on cases as to, if you like, the tribunal's instinctive approach to how loss shall be proven, in particular overcharge, because it very much starts from the principle that the focus of the exercise should be the econometric modelling, which we'll come on to in a moment under expert evidence. And there are some quite interesting statements there about what claimants will not necessarily be expected to do. Will, if you like, prove a case from the bottom up, prove that the consultation involved each individual episode of consultation, then had a downstream or up effect in terms of impacting upon pricing, and basically having to sew the whole thing together, but rather more suggestive of a sort of a top-down approach. Now, obviously, that has very important implications for disclosure and the extent that disclosure will be required. And I think in many ways was a deliberate attempt, if you like, and perhaps a laudable attempt to reduce the disclosure burden in these types of cases. However, maybe just to flag a couple of points there, which is that, first of all, on the question of causation, which, if you like, I think really is at the heart, if you like, of this sort of granular bottom-up issue. Does one need to go to the effort to link all these causational links together? In practice, it's harder to remove that burden for a couple of reasons. First of all, it's open to the defendants to plead that there was no causative link, in which case, in the usual way, the burden is upon a claimant to satisfy that. In which case, it's a sort of invitation, but nevertheless not one that one can accept, if you like, as a claimant. If the defendants are putting you to proof on a point, then it has to be proven, and disclosure has to be given in that regard. And also, of course, econometric modelling is not, as we'll come on to in a moment, is not the sort of cure-all in the sense that one has a sort of magic box into which one can tip some numbers and produce a magic answer. And indeed, one of the principal points of contention in any econometric model is precisely which variables are causative and which are not. And in particular, which variables can be disregarded as essentially outside, if you like, the causative factors of the cartel, and therefore can be controlled for, and which ones need to be focused upon and analysed. And whilst this can sometimes appear a little bit impenetrable, certainly to legalise, this is where we get into these wonderful regression equations. Actually, good old-fashioned facts and evidence tend to be quite important in sorting out what aspects were, if you like, within the ambit of the cartel, and therefore perhaps can be described properly as causative of loss, and those which were not and should be controlled for and disregarded. And that's a sort of old-fashioned lawyering job, which does need evidence to do that, I think. So there are some quite important points there, I think.
Great, thanks, Ewan. I think we should probably move on to some of the other topics, but we can certainly pick up on disclosure later on if there are any questions from the audience. So that again brings us on to the funding section of the talk, and I think it's fair to say that both disclosure and funding have been key parts of the English competition litigation landscape in driving things forward. It's frankly a lot more expensive to litigate in England than it is, often 3-5 times more expensive on some of the larger cases than in pursuing a claim in a continental jurisdiction. It's probably not really for me to ask questions to you on funding, although I have got some, but I'll just open the floor up to see if you have any questions on the funding space.
As you might anticipate, Simon, we at Housefeld have got quite a lot of experience of working on funded cases, and I just thought it might be interesting for the audience to hear a little bit about your internal processes. With the increasing number of standalone claims being filed, I just wondered if, from your perspective, there is a different audit of a case if it's a standalone case as opposed to where it's a follow-on case?
Yeah, I mean, I think I could probably give a bit of view from the Augusta perspective specifically, and I guess other funders generally will have different views, but there will be some similarity. I mean, I think taking a step back, funders put finance into a whole manner of different claims, not just competition cases. So yes, it's right that with a follow-on case, liability, you think that box is ticked, there's less to deal with, but it's not uncommon in many other investments where there are lots of complex issues beyond just quantum to be dealing with. And so in principle, there aren't that many differences in terms of the internal process. There are more issues to get comfortable with. Certainly if it's a standalone claim where there is no reference point to what the market is, or let alone who is dominant in that market, that there are some complex things to get you comfortable with. But like any investment, there are issues that you need to get comfortable with. You take them step by step. Typically you will have input from counsel opinion, some expert commentary, and it's frankly no different. There's just perhaps a few additional layers, but there's certainly, as you can see in the collective space, appetite for funders to be moving into standalone cases, and I think I mentioned that because it's the most public arena for funders to be involved, but certainly there are other standalone cases that are sort of individual actions which are being funded on a standalone basis. Yeah.
And hesitant to raise the B word too early, but I think it's interesting to me that with Brexit already happened, but effectively our end of the transition period, I wonder do you think standalone claims might in some respects in fact be more attractive because you are sort of freed from the shackles of the European appeals process, which has certainly been something that affects timescale of the progression of litigation for the English courts. I think not even where you have, for example, I'm sure as Ewan will have experienced, even where you have a settlement decision, that doesn't necessarily mean that you're going to proceed to trial terribly quickly. I think in trucks, what have you got the first trial listed for 2023, which I think given that the first claims were filed in 2016, does seem a very long and drawn out piece of litigation. But do you see any benefits to funding standalone claims and on the basis that they might be resolved faster?
Yeah, good question. Not necessarily an easy answer, but I guess there are a number of factors that need to be brought into the mix. So, from the funder's perspective, when you're assessing the case, you've really got to understand the underlying subject matter. To be able to step into funding a standalone case versus a follow-on case, I think you've really got to be taking a bit more risk, but also understanding the matter to be able to do so. You're absolutely right that in terms of return on investment, funders like to see things turned around quicker. Typically, that is a function of where funders source their financing from. Typically they are raising from institutional investors. There are pools of capital. There's often a life cycle to those funds that need to see a return within a given period. To an extent, it will be driven by how the funder allocates its funds. So some funders may ring fence funds and they will have one pot of money allocated to that case. Other funders might give the financial commitment under the ALF, but they may have other pots of money under access, and they've got the sort of flexibility to dip in and out of each of them. And so the extent you're exposed to a long running case will differ depending on how you manage your money, frankly. There are ways that funders can mitigate the time effects of the case. You can have a time function in your pricing, for example, so that you're less exposed to it. So to answer your question, it will be a function of how the funder sets its money up, and also, I guess, what the claimant or the law firm is doing. If it is one individual claimant, you can have a quite simple financing route between that party. If it is a sort of a claimant boutique who is building a book of claimants, you need something fairly simple to onboard sufficient claimants to get a critical mass. And in that world, you have to have a more simplified funding structure. It may not necessarily allow you to deal with that time value. And so you might actually, as you say, want a standalone case that resolves quicker. I think it remains to be seen whether or not a standalone case can resolve quicker, but I like the idea.
Do you ever find, Simon, when deciding what cases to fund or funding a number of different cases, there's a conflict in the, do you find yourself funding both direct and indirect claims arising from the same set of facts, or what other sorts of conflicts do you have to deal with?
So this is very much my personal view, so not the Augusta view, certainly not the view of the funding market, but I mean, from an investment perspective, there is one argument to say, is there really a conflict? Is it just an opportunity to hedge, frankly? Certainly in an indirect and direct claim, it's not always given that all of the loss is going to sit at one particular chain, and at the early stage when you're funding the case right at the outset, who is really to say where things are going to be? I mean, we see how far some of these cases have gone, and appeals after appeal about these issues. Even at that stage, it's not necessarily clear where the quantum sits in the chain. So in some ways, you might well want to do that, and I think it's really then a question for claimants when they're going out to source financing, if that is going to be a particular issue. Certainly, I think in terms of funders are very large, sophisticated operations if required, and it really then, how involved is the funder? If they're just providing financing, what does it, if you compare it to a bank, for example, a bank funds all manner of competitors, that's not really necessarily a conflict, it's just a source of financing. Great. I actually have one question on the funding side for Leslie, because I know that you're obviously involved in the representative action space, and we've seen the collectives funding a very clear role to play in the CAT for the collective action regime, and we've got some very helpful guidance in terms of MERICS and trucks as to how the funding will play out. But as the sort of representative action space moves into the High Court, I thought interesting to get your views as to how influential you think the law in the CAT is going to be, or to the extent the court's going to take a different view.
Thanks, Simon. Well, it is a bit of an unknown space at the moment. I think the judgment in Lloyd and Dougal is eagerly anticipated by those of us with skin in the game on the 19.6 claims front. And I think it'll be really interesting to see what approach the court adopts in relation to funders' return priority in terms of the distribution of monies to the class at the end of those cases. We've obviously got a very clear statutory regime in the CAT, and I think the current working assumption is that those are sensible principles that may well be followed by the High Court when it comes to address those issues in the context of 19.6 claims. So it's a bit of a sort of wait and watch this space, I think, when it comes to how the court will approach those issues.
Right, thanks. Well, yeah, I think there's plenty of funders who are listening in on the session who have got a keen eye on how things play out. I think looking at the time, we should probably move on to the next section in the session, which is the settlement. A number of very interesting areas to cover, and again, I think it's fair to say, certainly from what we're seeing on the funding side, the UK, partly driven by the disclosure aspects that we've discussed earlier, the UK is a forum where we're seeing a lot more settlements than we do in other jurisdictions. Typically if you look at Germany, Spain, France, cases are going not just a first instance, second instance before we're seeing resolution. But given the number of claims that we've seen on foot in England, not actually that many have reached trial. So settlement increasingly a key feature of the UK landscape, but lots of very complex issues. Most notably, as I mentioned, because of the cases are on foot elsewhere. I think the cartel landscape, where there are multi-parties, claimants and defendants, it's often been described as a sort of three-dimensional chess trying to resolve that because of the various claims that are on foot in your own jurisdiction elsewhere, and then at different tiers of the chain of commerce. So I think start with perhaps looking at this sort of the geographic strategy and potentially it overlaps with the indirect direct strategy on settlement. Ewan, you're probably involved in the most notable example of that with trucks. Any thoughts?
Sure. Well, I mean, and even not just focusing on trucks, as you've pointed out, Simon, they're often, it's a fundamental feature, of course, with cartels, and particularly international cartels, that they're multi-jurisdictional, multi-party, and quite often multi-layered in terms of affecting different levels of the supply chain. So the whole thing, if you overthink it, becomes a bit of a sort of a Gordian knot. And I mean, plainly, in some jurisdictions, there's almost like a culture, if you like, of mass settlements, not just in competition litigation, but also in general tortious claims as well. And that, plainly, when you're on defense side, is, if you like, the target to aim for, because you can take all of these uncertainties off the table at once if you can dispose of all of the risks. I think maybe just one little point to make, which is, of course, the driving force for settlements is usually the threat of judgment. State a rather obvious point, but that's ultimately the dynamic. And I think there are maybe just a couple of points to make in that regard. So firstly, you alluded to the time that the competition cases are taking in this jurisdiction. You compare, for example, to what's going on in Spain in the trucks litigation. Cases are coming on too quickly. Some people might say, sorry, too quickly rather than quickly. And even in Holland and Germany, they seem to be making much more rapid progress. I think we'll get the first case actually on at the beginning of 2022, which will be some 5 years after it was filed, which is a long time. Maybe just the second point is on this issue of complexity, because of course we have the interchange, and if you like, the examples of interchange, which Cassie is much more authoritative on than I am. But of course, you had in some ways some unfortunate consequences there of different courts hearing different cases stemming from the same conduct and coming up with very different results. And there was, if you like, an understandable desire to try and manage cases in the UK in a consistent way. However, of course, take that to the other end of the extreme, that you kind of can't do anything until you do everything. Until you get all layers of the claimant chain in front of the court at once and all the claims together at once. And there were some very interesting comments that came out of the Supreme Court in the recent Sainsbury's MasterCard judgment on that issue, which I think were really a big sort of dose of common sense, really, which was just saying, look, the role of the English courts is basically to deal with claims that come before you. And yes, there may be some potential for some inconsistency here and there, but you've just got to get on and do it. And that would, of course, feed into settlements, because as I think you will see now, which is the English courts being more prepared to let individual claims come through for trial, even where there are other ancillary claims, those will in turn have to generate partial settlements, unless, of course, the defendants take the view that they're happy to tough it out, see what happens. Cassie, I don't know whether you've got some thoughts on that as well from...
Well, from the point of view of trying to get all the cases together, one of the effects that I found from the unfortunate history of the various MIF cases that culminated in the Supreme Court judgment in June of this year is now, I think, a general agreement, if that's the word, but that all cases, all MIFs, because there are still a lot, hundreds of MIF claims still outstanding in what might be called, starting to be called the second wave of MIF litigation. All those to being transferred to the CAT, and the CAT being almost oversensitive as to how the cases are managed. And I've had experience of basically the CAT saying, well, we're not going to deal with anything in your MIF cases until we've dealt with the first in the queue. and because they're almost desperate to ensure that they don't do anything that might lead to inconsistency. But the problem with that is that we then have delay, and not a very common sense approach to the fact that there are a number of different claims and they have to be dealt with. So it's a tension between trying to avoid inconsistency, but at the same time dealing with cases in a practical and cost-effective way, because there's an oversensitivity, I think, on the part of the tribunal, definitely, not to end up in the situation that it found itself in the original first wave of MIF cases. So I don't know whether that in itself might have an impact on settlement. I think also picking up on a different point that Simon raised about different cases in different geographic, different countries. I mean, the obvious reason why I think a lot of the cases have settled in the UK and may go to trial in Spain a lot more quickly is just the sheer cost of litigating a case through to a full hearing in the UK. We see all these cases settling at the door of the court, and I'm not sure whether they would do that in Spain, but they will definitely do that in the UK, because you can avoid the thousands and thousands and thousands of pounds of just refresher fees, let alone anything else, even if you settle at the very first day of the hearing. So that's just maybe, I don't know if that's a good thing or a bad thing, but it's certainly something that I think does impact how things are done here rather than elsewhere.
Yeah, I think that's right. I think another feature is that distinguishes the UK, that perhaps facilitates the settlement, is the sort of incremental issue by issue resolution of points within the case, whereas in the continent quite often it's pleadings and then trial, and there's nothing really in between. So I think that's another function of the UK one, which is helpful for settlement.
I mean, you make an interesting point, Simon, on that incremental resolution of issues, and I think that does give you perhaps more stages in the UK where you might see settlement. I was really interested last week to see that Deutsche Bahn had reported that they had settled a number of their outstanding claims in Germany. So with 7 out of 11 airlines settling on the air cargo litigation in Germany. And now that's over 2 years since we settled the claims in the UK. And in fact, the claims in the US settled some very considerable time before the UK claims were settled. So I think it would be fair to say that defendants don't necessarily take a multi-jurisdictional approach when it comes to settling claims. They don't necessarily want to settle out liability in every jurisdiction at once. I think that is driven by the court's approach to process. And I noticed that in air cargo, I think there are claims still outstanding in the Netherlands that were filed even before the proceedings in the UK that are yet to be resolved. So I think there are some positives to be said about an interventionist approach in case management by the court, that they can push those increments and they can therefore push the settlement dialogue in those long-running cases through effective case management.
Ironically, the Netherlands, the jurisdiction which is easier to get compound interest, so why that one takes the longest to resolve.
Yes.
I wouldn't want to be the one paying out at the end on that one. So I think another interesting feature I think we're probably going to see more of, given the sort of increase in standalone litigation, I guess, is trying to resolve a case where liability is still an issue. I sort of tentatively say issue rather than done and dusted, because even in a settlement decision, as we've seen, people still try to contest liability. But yeah, we'll open it up to anyone who's got some thoughts on that.
I mean, yes, it's difficult, frankly, and I think data and analysis of that data is probably fairly key, particularly where you've got a cartel where there are multiple defendants or multiple addressees, and that may mean you've got either one defendant and several Part 20 defendants, or you've got a number of defendants. And I think what has proven to be key, and certainly in many of the cases that I've litigated, is being able to divide up liability between the relevant defendants. So that means interrogating client data being able to look at purchase volumes, being able to estimate where you've got missing purchase volumes, and taking a view then on which defendant is responsible for which set of purchases, looking at things like umbrella liability in a comprehensive manner, and effectively dividing up that liability between the defendants. And I think that is probably the way where you've got issues around liability. That seems to be a way of sort of unlocking settlement dialogue in cases, much as we hate doing it, and the data work is often very time consuming and very expensive. It does seem to be something that pushes the envelope in terms of settlement dialogue.
Cassie, I mean, in terms of the strategy around settling something like that, and also, I guess, some of the practical functions which go into achieving or executing a strategy, if you were to face the option of a split trial on liability and quantum, or just press on ahead and bring everyone closer to that final trial date as soon as possible. I mean, a lot of different things that go into that, but interesting to know your views.
Yes, I think it very much depends on the type of case, doesn't it? And whether you've got, I think I'm very much with Leslie about whether it's about the data. And first of all, whether you've got a real issue around liability, whether that's going to be a problem. I was thinking about standalone claims versus follow-on claims, and a few of the standalone claims that I've been doing recently and how you establish liability in those claims. It seems to me that standalone claims are very unlikely to be cartel type situations, because you're unlikely to be aware of the cartel unless there has been some investigation. So as a claimant, you're unlikely to be aware of any sort of cartel unless there's been an investigation. So there will be something to work with when it comes to liability. The type of standalone claims I'm doing at the moment are based on more publicly available material. They're based on the operation of certain financial rules. They're based on the operation of a particular contract. So the material is there. It's then a question of what is the actual effect. And it's those questions tend to be more expert-driven type of questions. So it may be that, so it's a very different situation in a standalone claim like that about establishing liability. So you might think in a claim like that, for example, that there's a value in splitting out liability and quantum, because if liability is very strongly contested, you get to a position where you've got a judgment on liability, then settlement might be a lot easier to follow. Very different when you're looking at a case that might be a follow-on case, or a follow-on case with standalone aspects to it, where it might be better to push ahead with all issues at once, including both liability and quantum and causation, of course. And then the question will be, often in those type of cases, a more classic cartel case, it'll be a question of how you manage the fact that there are likely to be a number of defendants, and there's likely to be disputes about how the quantum is to be split between those defendants. And then, as Leslie said, there's a lot of data that you have to gather. Simplest way of splitting quantum will be by reference to purchases, but that's not the only way. I mean, I've acted for parties who are defendants who have had no sales to the claimants, but nevertheless, in principle, are liable for the damages arising from the cartel. So those give rise to very knotty issues when you're thinking about settlement.
Yeah, absolutely. I mean, my experience is typically the settlements, defendants typically only settling in respect of their own commerce, you know, even where there is in principle joint and several liability. So yeah, absolutely, some tricky issues with settling cases where you haven't actually sorted anything. Just as a final thought on settlement, I thought I might just bring up the collective action space, because obviously the regime has it has mechanisms which are designed, I think, to incentivize settlement in terms of reversion. Very different to the US triple damages sledgehammer, which objectively, you know, from my perspective, something I'm certainly not advocating a triple damages thing, but I think if you're comparing the two, very different incentives there, and not least because, you know, in the sort of post-COVID world where cash is king, even if you are to settle and get some reversion, you've still got a pot of money sitting there that you can't be using in the interim. I just thought I'd just get people's views on whether or not you think the reversion mechanism is going to be an effective tool in settlement of collective actions. Or indeed any other comments on the collective space.
Well, let me have first go. And I was lucky enough to be sitting on the CAT user group when some of the sort of discussion around that mechanism was being had, and what we eventually ended up with in the CRA. And I mean, certainly I think an overriding principle of the settlement mechanisms as they apply to collective actions in the CAT was the need for a representative to accept effectively that once it had obtained a CPO, then the progression of the case, and including settlement, was very much to be conducted under the supervision of the court. And that is, of course, reflecting the fact that under that regime, in some senses, the CAT is almost putting on a sort of consumer protection type of hat, and will want to ensure that all aspects of the case, including settlement, are run in the best interests of those parties who are represented, but of course not there. So the overriding point is that if, in a way, one has much less control over some aspects of settlement in that sense, and the same will be true if an application is made for a collective settlement order, which, you know, is of course another option available under that regime, but again needs to be approved by the CAT as in the interests of the parties. In terms of the residue, I have to say the honest answer is I just don't know, because, you know, we're yet to go through that process, and maybe just to note that it is a feature, and perhaps a surprising feature, that quite high proportions of collective settlement pots in other jurisdictions remain unclaimed. So it's not sometimes sounds as though it's a bit of a rounding issue, because it sounds a little bit counterintuitive, but it is an important point. But others may have views on that, but it's quite a tricky point.
I mean, I think just looking at the time, I might save you all from having to give views, because I think we're shortly to be joined by the discussants for this session. We've got two excellent additional speakers who'll be joining the panel. First of those is Alexander Carbonell of NERA, and we've also joined by Daisy McKersey of Monckton. So Alexander is the lead competition lawyer in NERA's Paris office. He's worked on standalone and follow-on matters, and also arbitrations, which is an interesting space for competition disputes. And historically, on this side of the channel, is many moons ago worked for the OFT, or what was known as the OFT at the time. And Daisy McKersey, she's a junior barrister at Monckton with a thriving competition practice. She's currently acting on the defence side for FX and also on trucks. But like all good barristers, also has some claimant side experience on both standalone and follow-on matters. So two excellent speakers to help kick on the conversation. The rest of the agenda is expert evidence, and then hopefully a little bit of time for Q&A at the end. But since we've got Alexander here, probably suitable to give him the opportunity to kick off on experts. And I think I was going to kick off with something along the lines of hot tubbing, and I think you've got your own views based on some personal recent experience. So why don't you expand on that?
Yeah, indeed. Thank you very much, Simon. So, yeah, in my experience as expert in a recent international arbitration case, the question of confrontation between experts, so the so-called hot tubbing, has arisen in a situation where the tribunal faces very complex and technical issues, and it's difficult to form a view. And in this case, you know, maybe cross-examination and testimony format just does not really help. So, for instance, you know, just to give an example, this arises when you have opposing views between experts on some for instance, econometric questions, right? And it's just difficult for the tribunal, and the tribunal needs more information in order to come to a conclusion. So, from an expert perspective, the hot tubbing setting gives you the opportunity to be in a bit more of an informal setting and more informal discussions with the tribunal and the opposing side, and in a sense it's more natural. But there's a consequence to it also, which is that as an expert I really need to be on top of things, because the lack of knowledge of the case can quickly show up in the discussions between experts. So I think there are potential benefits to hot tubbing, but there are also some risks that are associated to it. And I would be interested just in hearing your experiences with respect to this, and just more generally your views on the pros and cons of hot tubbing.
Thanks, Alessandro. Yeah, please, anyone else with recent or ancient experience of hot tubbing? Good to get some views.
I can say a few words about some not so recent experience of hot tubbing. I think in my experience, I have done some hot tubbing in cases, and I also have had cases where we've obviously cross-examined the witnesses. I think that the success of hot tubbing turns very, very much fundamentally on, first of all, what the issues are that are being addressed, the nature of the issues that are being addressed in the evidence being given by the expert. And then secondly, and also quite fundamentally, the tribunal or judge who is leading the hot tubbing. Because hot tubbing I have found to work in a situation where the issues were quite limited. Question of definition of a relevant market, for example, and where the hot tubbing, where only two experts, two parties, a very limited question, and being led by a judge who had expertise, so was able to lead the questioning and not be led by the experts. Because that I think is a big danger, and that worked very well in a situation where the judge had it was a relatively limited issues. The judge had expertise and was able to lead the hot tubbing and the questions, and it did have that effect that I think Alessandro has given, that when you're sitting next to a peer, as an economist, you're sitting next to a peer and colleague who you probably respect and know. It does make you a little more honest and a little less likely to go out on a limb than when you're being face to face to some stroppy barrister. So it can work very well. At the other extreme, I don't think it could work so well. It would work so well in a situation where there are a number of parties. I know just recently in the power cables litigation, we had 2 claimants and about 6 groups of defendants. So a whole cast of thousands on the expert side. Trying to get 8 experts in a hot tub. I mean, just physically, how does that work? How does that process work? 8 people lined up in front of a judge. And then also the issues the experts were addressing in a case like power cables, which we never got to court on that one. But there were very technical, very detailed issues of econometric modeling, working out the quantum. They're not the sort of issues that lend themselves to a civilized discussion being led by a judge. What I think in that case, what works better, and again, this is probably just where I'm coming from, and I'm willing to be challenged on this, but what works better in that case, I think, is more forensic questioning by an advocate who has a particular point they want to bring out, or a particular question, an issue they want to pursue. So I think it can work very well, hot tubbing. I think that it's not the answer in all cases, and definitely not the answer with certain issues. So I'd be interested to hear what others' recent experience has been and what their feelings are on that.
So I think just a couple of brief points, which is I think I attended the first ever hot tub in a CAT claim, which was in Healthcare at Home in Genzyme with Sir Christopher Bellamy and then the late Marion Simmons. And that worked very well because exactly as you said, Cassie, it had very experienced bench and very limited issues. But I would echo the points you've made about when there are a large number of experts and a large number of issues, the whole thing becomes very quickly unmanageable and slightly can be arbitrary in its results as well, precisely because one can't be quite clear about what issues are being fed into the process and who's able to comment on what, and there's a real danger of unfairness actually. I think the better way to approach it is very much just as one of a range of tools that can be used when dealing with expert evidence, you know, including trying to the extent possible to get some form of agreement on issues, and equally helpfully clarity around what issues are not agreed, and also timetabling a series of meetings between experts on different issues in the lead up to trial. I mean, there are some fairly fundamental but basic issues such as value of commerce. You know, what transactions are in and what transactions are out, which if lawyers want to litigate that sort of point, you know, has enormous potential for wasted cost and time. But frankly, if the experts can get in a room and at least agree, you know, the broad areas, etc., can be enormously valuable. So I think one of a series of tools, I think.
Thanks, Ewan. Well, since Cassie has suggested that advocates need to get involved in asking experts the questions, I thought I'd open up to Daisy to see if you've got any particular questions to ask.
Sure. Well, I wanted to pick up on something that Ewan said about it being one of a variety of tools, and ask the panel whether they think that the CAT is becoming increasingly keen on hot tubbing rather than seeing it as just one of a range of tools. Cassie, you mentioned power cables. And I actually saw, I wasn't involved in the hearing, but I saw that in July, I think at that point there was one claimant and at least 3 or 4 defendant groups. And the issue of hot tubbing was hotly contested, and the tribunal did go ahead and order it. And so I was interested in the panel's views on whether they think that the CAT is actually taking itself down a bit of a rabbit hole with hot tubbing.
I mean, yes, like most of these issues, I think everything will turn very much on the facts of the case. And it is absolutely clear in the tribunal that hot tubbing is now not the norm, but certainly parties will need to address the tribunal on whether it is appropriate, and if it isn't appropriate, why. And again, I think this is still, there is a slight difference in attitude between the tribunal and the High Court, in that it is seen as more, the tribunal is certainly more open to the possibility of hot tubbing. I'm not sure it'd be seen as the default option, but it's certainly an option that they will expect, the tribunal will expect you to have considered and to be able to say why it is appropriate or isn't appropriate. Whereas still in the High Court, it's something that is seen as a little bit of a novelty. So again, though, it's a difficult one, because I totally agree with you, and that is one of a number, and that the advantages that were elucidated by Alexandra about getting experts to agree, etc., might actually be done more effectively in joint expert meetings before we even get to trial. And that is definitely, I think, an extremely valuable tool that courts should require experts to meet before trial, should require experts, which I think is now done as a matter of course in the High Court and the tribunal. But they should meet, they should draw up issues, lists of issues agreed and not agreed, and they should meet, if necessary, on a number of occasions to seek to narrow the issues, because there are a lot of issues that should be able to be agreed, and then we can focus on the difficult, more nitty-gritty issues.
Thanks all. I mean, one sort of query I've often had is use of experts, and typically we think of competition disputes as areas for economists to opine. I think it's fair to say, most of these areas, defining markets and quantum in these complex counterfactuals, economists are the appropriate people to use. But increasingly, we're going to see more complex disputes, potentially areas where market experts need to be used. And if I keep an eye on what I'm seeing in other jurisdictions, I think where they're evolving, they are less well versed in the competition world, less familiar with economics, and sometimes a forensic accounting approach, for example, is more intuitive for them, just given the background of maybe some of the judges there. So frankly, there's probably a role for many of these experts in some of these disputes because of the number of issues. Certainly, as they become more complex, I thought I'd just open up to people's views on use of different experts. I'd also be interested on Alexander's view, given an organization like NERA, how you piece together different experts in sort of helping a particular case, and then from the lawyers, when you're choosing your experts, how you assemble your team, so to speak.
I'm happy to go first, if it's okay. Thanks, Simon. Yeah, I mean, we do work with other experts, right? So, for instance, accountants or technical experts. So we work together on cases. Obviously, we work on different issues, but it still requires some coordination. We need to make sure that the arguments are aligned and there's no contradiction anywhere in what we are saying. I think one of the specificities of the work of economists is that we often request a lot of data, just because our conclusions are based on empirical analysis. And Ewan mentioned the econometric work. That's often what we do in projects, and we need large data sets and very disaggregated data. And at the hearing, if we have not asked for the necessary data, then that can go against us, in the sense that tribunal may say, you've had the opportunity to ask for data, you did not ask for it, so now you cannot complain. So yeah, it's a really specific role, I think, the one of economists on projects, and it's often related to the availability of information and data to reach our conclusion. So that's why you discussed disclosure. All of this data collection, I can understand it's a burdensome process, but it's also very important for economists, and maybe more so than for other types of experts that do not rely as much on data. And so yeah, I mean, I would be really interested to hear the views of the panel on the different types of experts, what are their role, and also maybe there are some specificities in the UK as opposed to other jurisdictions.
I think Alexander made an interesting point about the use of different types of experts. Certainly, I think Ewan referred earlier when he was talking about the approach of the CAT in trucks to pass on. It's not necessarily an economist who might be the individual opining on the position as to pass on of an individual claimant. When we put together our reports on pass on for our cargo clients, we actually used forensic accountants. And I can anticipate a world where actually there is an increasing role for those different types of experts, so forensic accountants, as you say, market experts, to be addressing issues like pass-on, which are a sort of market-specific, backwards-looking form of analysis. And I've also seen, which it's put out for comment, an increasing trend, I think, of the court to use teach-in sessions at the start of hearings where the court is addressing really technical or complex markets or factual situations in a particular cartel. And I think that's been a really useful development in competition litigation, is being able to get the tribunal's panel familiar with how the market operates, to get them familiar with the technology that's at issue. And I think that's a really positive trend in these cases where we have those early stage teach-in sessions for the benefit of everybody.
Thanks.
Yeah, I think that's absolutely right. And I mean, maybe just a couple of quick points as well on the expert point. Echo what Leslie said about forensic accountancy evidence, and of course there's an interesting question as to the extent to which that will become more important after the Supreme Court's findings in Sainsbury MasterCard about the role that so-called mitigation should play in the context of competition damages actions, and which I think is an issue that probably is one that might well be led by forensic accountants. I think maybe just the other point of what Alexandra was just saying, and it slightly goes back to what we were saying earlier about disclosure. What's interesting and perhaps a little bit unusual about the UK in the context of the econometric work that is carried out in cases in this jurisdiction, I mean, is the extent to which costs disclosure is sought and given, actual costs, so a defendant's actual costs, because in many jurisdictions the modelling will often rely upon proxy costs obtained from public sources in order to build the econometric model. This was, of course, it's not a methodology unheard of in the UK. I mean, BritNed is an example, but has not perhaps been successful when applied. So I do think that's useful, and basically goes back to what I know is one of the central principles of academic teaching of econometrics, which is the complex and learned principle of garbage in, garbage out, in the sense that it's desperately important to try and get the data correctly identified at the outset, and also actually the context in which that data exists. So if you haven't been able to see the management accounts, you don't really understand what a company's data actually means, what it was used for. You know, is it a true cost, or is it a benchmark, etc. And without that sort of understanding and having all of those types of issues resolved before trial, the scope to go round and round in circles in cross-examination during trial, or thrash around in your hot tub, are enormously high, I would have thought.
Thanks, Ian. You know, in terms of other issues on use of experts, I mean, one question I've always wondered is, you know, given so much of this is follow-on litigation, what do you do when you want to challenge what a regulator has found? I mean, Cassie, I mean, even when we're not talking about the private enforcement, where you're just challenging a regulator's view, and Leslie, obviously, you've been involved in some standalone matters or some standalone elements to things where you're looking at what the regulator has found, and how do you approach that in terms of expert evidence, and any kind of thoughts there?
Well, again, it depends on what sort of case you're dealing with here. I mean, in a classic cartel case, a classic cartel decision, generally you'll find that the Commission will be as careful as possible not to make any findings on the effect of the cartel. So we'll be absolutely desperate not to say anything about what the effects of the cartel might be, and simply focus on object. So leaving open, I think on purpose, those issues to be addressed in any follow-on claims in expert evidence, both as to causation and quantum, and even as to questions as to how the cartel actually operated, and whether it even had the effect, any effect on prices or competition in the market more generally. So you'll find that you're taking up the sort of mantle from the Commission and taking things a lot further with experts.
Yeah, sorry, to clarify, I probably should have, sorry to interrupt, I should have clarified. I was thinking more in the sort of dominant space where you're sort of challenging market definition and things like that, and that side of things. So not strictly on the cartel space of it.
I mean, it's a really interesting issue, Simon. I think it, it is one that we will have to increasingly tackle going forward. I think it'd be fair to say that I certainly don't feel myself particularly bound by whatever the regulator says the geographical scope of a cartel is, or the time period. There are often other reasons at play, not least resource constraints on the ability of a regulator to investigate the full duration of conduct or the number of territories which it covers. And that's something that you are more able to do in private damages litigation, where you will see often a sort of hybrid claim where you have sort of standalone elements that effectively plug on an earlier period to a cartel or a territory that's not addressed by the European Commission. And I think in the tech sphere, increasingly, the Commission is very conscious of the criticism it has been under for taking too long to make decisions. And so it is framing its investigations in a very narrow manner in order to ensure it can make a decision quickly, and then hoping that conduct is adjusted in other markets or potentially in other geographic territories, sort of following on from the findings within that decision. So I think it will be more the case that we see sort of example type decisions of conduct in a jurisdiction or a market that falls foul of the competition rules. And the Commission will hope that, in fact, that precedent leads to a change in behaviour in other markets. I don't know, Daisy, if you've got maybe some comments, say, on perhaps the weight given to regulatory decisions in other jurisdictions. I think that was something that has come up in a number of the cases that I've been involved in, where you see regulatory decisions in other jurisdictions, not least the US, but you might also see them with some of the more active Asian regulators like the KFTC. What sort of impact do you think that has where you have a sort of global cartel behaviour or global abuse of dominance behaviour? Do you think that's something that the UK courts are interested in or find persuasive in any respect?
It's a really interesting question, and it engages with the point that was made earlier that actually increasingly now we're seeing, not only in trucks but also in FX, for example, parallel claims in different jurisdictions. And how does the issue of consistency and case management play out against that background? In terms of the weight given, I haven't seen that being a particular issue in terms of the actual regulators' decisions. But one point that I was actually interested to hear everybody's views on is how you think those parallel claims might have knock-on effects for case management in cases in this jurisdiction. So, for example, Ewan was talking very interestingly earlier about the other trucks claims, and that doesn't really seem to be a factor that's fed into the way that the CAT's managing those claims. On the other hand, in the High Court, in the FX litigation, in August, the progress of disclosure in the US had a direct effect on what the court was prepared to order in terms of deadlines for pleadings and so on. And I was very interested to hear actually whether any of you had any experience of the court being interested or completely uninterested in what was going on in other jurisdictions.
I think what's been interesting for me perhaps is that a defendant might not necessarily find themselves bound by perhaps admissions of guilt or plea bargains made in other jurisdictions when it comes to effectively identical or very similar conduct that's then the subject of European cartel decisions. So, I mean, you're right, the court doesn't, I think, find itself persuaded by regulatory decisions in other jurisdictions, but where evidence is perhaps available through those processes. For example, in the US, evidence is often not under seal and is therefore publicly available. And there are sometimes expert reports that are again publicly available. I think the court is interested by those, particularly where it's a credible, sensible regulator that is respected by the UK courts. And I do think that does play a role. They are interested in what's happening in other jurisdictions. They're interested in admissions in other jurisdictions. So certainly that's been my experience of the impact of those regulatory decisions in other jurisdictions on UK litigation.
There's another quick point on that is that, for example, in auto parts, the dynamic is not felt so much at the court level, but actually at the settlement level. And of course, you know, where the US has led the way with settlements, then either, you know, the UK or European proceedings can be dealt with by way of ancillary agreements to those US-led settlements, or drive settlements in this jurisdiction, just simply because the very difficult position to be in as a defendant, obviously having given away one side of the case but not necessarily the other. I think in terms of the actual question, I think in many ways it works better the other way round, or is more meaningful the other way round, in the sense that I think the English courts quite rightly consider the inquiry and the nature of the inquiry they undertake to be somewhat more detailed in many respects than that undertaken in other jurisdictions. And therefore, I think sometimes there's more weight, if you like, and anticipation placed upon the outcome of English cases, certainly to date, than perhaps the other way around. I mean, the contrasting the Spanish as opposed to the English processes in trucks is perhaps an extreme example. However, if everything is changing so fast in this area, and the fact that the English cases are taking so long may well mean that there is a different dynamic, as is the growth of cartel litigation in Holland and Germany in particular. But it's a really interesting question.
Yeah, I think the only comment I might have from an investment perspective, when you're building your investment strategy on a cartel case or otherwise, where you sort of pan-European opportunities, there's a lot of fun to be had in terms of assessing all the different timelines for cases and predicting when things are going to be resolving. And actually, if you map things out on trucks, there are actually, I mean, it's only my own view, but I think there are a number of interesting junctures for resolution across the different cases which line up. So anyway, that's my own personal view, but we'll see. It remains to be seen whether or not I'm right on that. We're probably coming right to the end of this, so I don't know if we have time for one last final question, if anyone has any, but otherwise I might just wrap things up. Great. Well, thanks again to the panel for joining. I hope everyone's enjoyed today's session, and as a final thank you to Grant and Pam and Thomas on the nearer side, and John Keegan and Moncton and all of the team there who put together a fantastic session. I hope you've all enjoyed the conference. We've got another great session lined up later on today, and I hope you can all stay on for that. And otherwise, I'm going to hand over to Pam to conclude things, but thanks again.
Thank you to all of our panelists and discussants. This was a great session. We're going to take a 30-minute break and reconvene at 4 o'clock for a terrific panel discussing class certification battles. Please be sure to check your Outlook diary for the session Zoom link. You may also visit the event's website to log on to the session. If you have any technical questions or are unable to join the next session, please email events@neera.com. We will see you in 30 minutes. Thanks, everyone.